Chapter 4, Privacy, Part 3 of 7, Electronic Surveillance. The learning outcomes include: discuss how the courts have balanced government need to know with individual privacy rights. Describe laws that prevent agencies from gathering information without just cause. And assess how the Patriot Act increased the ability of the government to secretly collect data on you without a warrant. People often infer privacy rights from the Fifth Amendment, which says that you won't be held to answer for a crime unless the case is presented to a grand jury, which indicts you. Opponents of the gag orders issued with national security letters extrapolate from the Fifth Amendment and argue that there should be oversight from another branch of government before your First Amendment rights are infringed upon. Let's look at some examples of controversial decisions regarding electronic surveillance. The courts have made several rulings that affect electronic surveillance. First, they established the FCC to regulate government use of radio and television broadcasting. Otherwise, there would be an unbridled competition for limited bandwidth, and those organizations with the most money and the biggest satellite signal would always win, thus eliminating the voice of smaller markets. The FCC also regulates all interstate telecommunications and international communications that begin or end in the U.S. Title III of the Omnibus Crime Control and Safe Streets Act regulates how wire and oral communications are intercepted and allows law enforcement to use wiretapping as part of a lawful investigation. This is known as the Wiretap Act. Where Title III becomes interesting is when it's linked with FISA, or the Foreign Intelligence Surveillance Act. FISA has been in the news recently with competing memos released in early 2018 describing how warrants were obtained on a former campaign worker for Donald Trump. FISA requires a warrant like any other legal procedure. However, FISA courts are secret and must have a foreign intelligence component. Although U.S. citizens may be a part of a FISA warrant, the warrant must also include foreign information. Thus, if you're communicating with people from Russia or Iraq or other countries, and if someone there is suspected of espionage or terrorist activities, then you could become embroiled in their issues. The Electronic Communications Privacy Act, or ECPA, was passed in 1986 in an effort to protect transmissions of electronic data by computers, extending the original act, which dealt with traditional telephone transfers. ECPA also provides protection for communications that are stored electronically and prohibits devices from recording, dialing, or other information without a valid search warrant. ECPA desperately needs an update, but remember, laws and government bureaucracy never keep up with technological change. Thus, it's incumbent on you to protect your own privacy. Take a look at these two YouTube videos for more information on internet privacy rules and your lack of privacy while you're online, making a cell phone call, logged into an open Wi-Fi connection at Starbucks, or sending an email message. The Patriot Act expanded upon the government's ability to request for access to personal records stored on organizational computers. While many have challenged the constitutionality of national security letters, or NSLs, the gag provision is perhaps the most oft-criticized portion of the law. A national security letter compels the holders of personal records to turn them over to the government immediately upon request. Laws granting the FBI authority to issue NSLs were passed in 1986 and then expanded in 2001 under the Patriot Act. NSLs are issued by the FBI without prior approval of the courts, based on the assertion that the records are needed for national security interests. They are almost always accompanied by a gag order that prevents recipients from disclosing that they even received a national security letter. They can't tell the board or regulatory agencies, customers, or family members. They also cannot criticize the actions of the FBI in serving the national security letter on them. The only appeal is through federal court. There are no appeals of the court ruling there and no discussion of the case until and unless the court determines that the gag order is lifted. While only about 20,000 or so NSLs were served prior to the Patriot Act, hundreds of thousands have been served in the years since. So let's look at 3 of the known successful challenges made by those who received national security letters. The Internet Archive successfully appealed and won the right to talk about their national security letter, with federal judge Susan Ilston stating that the gag order provisions of national security letters violate First Amendment rights and even ordered the government to stop issuing them. As a result of that case, Congress amended the NSL statute as part of the USA Freedom Act in June 2015. Another notable case is Nicholas Merrill, who was CEO of Calyx Internet Access when they received a national security letter. Merrill objected to the gag order of the NSL and fought in federal court for 6 years. Finally, he was allowed to share what happened, successfully challenging the ability of the FBI to issue a gag order for national security letters. Since that time, several other powerful technology companies, including Google, have gone public when they received national security letters. Another law affecting electronic surveillance is the Communications Assistance for Law Enforcement Act, passed in 1994. This law required telecommunications providers to build tools into its products to assist federal investigators in their investigations. A court order is required prior to receiving permission to compel compliance. This law came into the public discussion recently, where the FBI asked Apple to help it break into the iPhone of one of the San Bernardino killers. Apple refused, and the FBI took them to court. Apple said that it would not provide a way to overcome its own security and violate its terms of service agreement with customers. They also stated that it would take them some time to develop a backdoor and they shouldn't be doing the FBI's work for them. The FBI abruptly withdrew their federal court challenge. Although not made public, it is believed that the FBI paid someone about $1 million to provide them with a way to overcome Apple's security. You can see here that Edward Snowden's opinion on the FBI request. He believes that they didn't need and shouldn't have requested the FBI's help, as shown in this YouTube video. While the federal government argued that this was a one-off case and they wouldn't be asking Apple or Samsung or Motorola or Google for a backdoor into any of their phones. It's not clear, though, if that's the case or not. There are already some state cases that are asking for help in unlocking cell phones for gang activity in inner cities. Opponents worry that privacy rights will continue to be chipped away, while proponents argue that there needs to be widespread cooperation between government and industry. Which side are you on? In summary, law enforcement must have reasonable cause and obtain a warrant prior to wiretapping your phone. The Patriot Act greatly increased the ability of the government to secretly collect data on you without a warrant. The recent trend has been toward individual rights as opposed to governmental need for information. Individuals and organizations must be vigilant about their own data privacy and security.